Vamos a iniciar la sesión. Good morning, everybody. We're going to start this session. Antes de iniciar, quiero recordarles.
Before we start, I'd like to remind you that we will have interpretation from English to Spanish and Spanish to English. If you wish to hear the interpretation, go to the globe at the bottom of the screen where it says interpretation and click on the language in which you would like to hear the session.
Please go to the little globe that says interpretation and click on the language on which you want to listen to this session. So I'm very es un gusto darles la bienvenida a esta sesión.
It's a pleasure to welcome you to this session. My name is Carla Sáenz. I'm the Regional Bioethics Advisor of the Regional Bioethics Program of the Pan American Health Organization. And we are part of the Unit of Science and Knowledge in the Department of Evidence and Intelligence for Action in Health. It's a pleasure to be with all of you today at this last session of the regional workshop on MTA, material transfer agreements and data transfer agreements for research purposes. I will be briefly sharing a few slides, introductory slides. I'm sorry, I think it's appearing in a bit unusual format. But anyhow, this is just very introductory slide, general slide, just to let you know that we are in the last stretch, the last session of this regional workshop, where we will be discussing the regulations, the existing ones, which are very few in our region, as well as how we could conceive of future regulations for this topic. I would like to remind you that we have organized this session as part of the activities that have come about for the purpose of implementing what appears in our publication, emergency use of MTAs, DTAs, and the pending agenda. In Chapter 6 of this guideline, we mention the topics that have to do with the sharing of samples and data in ethical ways for future research. And we do that because one of the recommendations in this publication is that it is important to train people on the MTAs and DTAs and the use of them. So that's the part of our regional agenda that we're now implementing. Before we begin the session, I'd like to invite you to visit the webpage of the Regional Bioethics Program, PAHO. You can see the QR code here, which will take you directly to the website. And through it, you will be able to subscribe to the regional listserv for ethical research. I'm also sharing the QR of the publication for our publication on catalyzing ethical research in an emergency. There, you not only see the full publication, but the summaries and the recommendations for ethics committees, for health authorities, and also a series of slides that you can download to if you wish to present the content of that publication. So now it's a great pleasure for us in the Regional Bioethics Program of PAHO to introduce to you Dr. Barbara Beer. She's a professor of medicine, specifically pediatrics at the School of Medicine at Harvard Medical School. And she's a hematologist and oncologist at Brigham and Women's Hospital. She is the head of the program on regulations, rights, and ethics for the Harvard catalyst. And I will say it in English because I can't think of an exact translation of the Harvard Clinical and Translation Science Award. She's also the head of all regulatory policies and the project entitled Smart IRB, which could be translated into Spanish as a intelligent ethics research committee. Dr. Beer has been co-founder and now heads the Center for Multi-Regional Clinical Trials, which is a collaborative effort throughout the entire university for the purpose of improving ethics, responsible behavior, and the regulatory framework for multi-site, multi-regional clinical trials. Barbara, it's a pleasure to have you with us. Go ahead, please.
Thank you so much. It's a pleasure for me to be here, and I really welcome this opportunity. I have been given the assignment to talk about, as an introduction, material transfer agreements and data transfer agreements, which I will refer to as MTAs and DTAs. Again, I have no conflicts of interest with this material, but I am expressing my own opinions and not those of the hospital or the university. We are a center that's supported by voluntary contributions as well as by grants, and you can read about that on the website. The agenda today is to define MTAs and DTAs, to discuss when we should think to employ them and when do we need them, who's responsible for developing them, some thoughts about some essential concerns and considerations in developing them, what are important components, what are less important components, and then who can sign them, who has the authority to actually execute them. So an MTA, material transfer agreements, are contracts, legal contracts that define the rights and obligations of both the provider and the recipient of materials used in research. So those people who give them and those who receive them. Any material that can be biological materials such as DNA constructs, proteins, cell lines. They can be organisms like whole mice or yeast or plasmids. They can be chemical compounds like drugs and pharmaceutical products, devices, biologics. Can also be software programs and tools. Anything that is a thing. DTAs, data transfer agreements, are used where only the data or data sets are being transferred. A DTA will be used for the transfer of anonymized data, pseudonymized data, that's de-identified data, or personal data that's fully identifiable. DTAs are sometimes called data use agreements, and those are a type of MTA. And when an MTA is going to include data or materials as well as data, we generally wrap them into a statement that's an MTA. The principles are very similar. It really has to do with some of the issues are different. The principles are the same. It has to do with whether we're talking about data or materials. So the DTAs are only data or data sets. They set the related protections, rights, and obligations of both parties and delineate the specific purpose for which the data may be used. So a DTA will specify what limitations there are to how the data is used and to what purpose, how it can be shared, how it can be transferred. Some DTAs, as the contract, they use the term DTA for non-human subject data or completely de-identified anonymized human subject data. and then DUAs, data use agreements, for the human subject data that includes personally identifiable information, personal health information. In the US, the DUAs that contain this minimum necessary or identifiable data are subject to HIPAA regulations, may require ethics approval, and in other countries, there is often a difference between data that is identifiable versus the rules and regulations and laws that surround anonymized data or non-human participant data. I think that a lot of these names are used and are often used interchangeably. People are not precise about whether they're talking about a DTA, DUA, a DTUA, a data transfer and use agreement. So I think of them as all contractual agreements that are used to define how data that is exchanged can be accessed and or used, and what are the responsibilities of the providing party and the receiving party. And if you think about it in that way, it sort of is a bit more of a lumper than a splitter. You think about what is being transferred. Is it data? What is that data? Is it identifiable? Is it human? Is it not? Is it identifiable? Is it not? And then is there materials, things being transferred as well? Generally, an MTA or DTA is required for all incoming or outgoing material and or data transfers, except those that are purchased commercially. So if you buy something, generally you don't need a material or data transfer agreement, an MTA or DTA. When do you need it? If you're getting material or data from another entity, we call it an MTA in. In other words, it's incoming to the institution. And if it's leaving material or data is leaving the institution, we call it an MTA out. The reason for that is that the issues for the institution, you're going to be on one side or another, either receiving or giving. Those issues are quite different. So thinking about it in terms of who is providing, who is receiving, and those responsibilities helps the purpose and helps one to think about this. When you transfer data or materials, the commercial transfers differ from non-commercial. In other words, if you're dealing with an industry partner or you're dealing with a for-profit institution or body, that's very different than you transferring for non-commercial use, for educational, public uses, those kinds of things. And I'll say that most institutions are more sensitive and worried about commercial uses, and equally, commercial entities are more worried about nonprofit institutions and use, because somehow the companies understand the limitations of use and respect them, apparently with greater depth and compliance than academicians and people in the nonprofit sector. What are the concerns? Really, things like fair remuneration, fair cost, fair response for transfer and license to use. How much are you going to get? Is that enough for the purpose to which it's being used? What about control over the downstream development? I give you an essential reagents, and then you go and develop something that is useful to the population, and now you price it out of control, out of access for my population. That is one of the challenges about exchanging, for instance, new viruses or others, that companies will take the virus on an MTA and develop a therapy about it, which is then unaffordable in certain communities and prevents wider access. incremental improvements that cannot later be deployed because all of a sudden something that was done publicly has been improved upon, much more useful, and now it's strapped with and bound by commercial control. We are much more worried about new discoveries, druggable pathways, targets, new IT, new software, those kinds of things, than when we're looking at translation, whether there's a new indication for an approved drug or biologic. And that's also different than when we look at a clinical trial itself. In other words, if we're looking at a composition of matter and a drug company has a drug that is going to be used in a clinical trial, there's often very little new intellectual property that can come from that. So we worry about it less. That is, and there are equal and justified concerns with nonprofits by the commercial entities as well. As I mentioned, the control over the intended use and discovery. So if a commercial entity gives an academic a reagent and they do something novel, that company usually wants the right of first refusal to any downstream further development. And then they're also worried about interventional use, safety, and product labeling. If a company gives you a drug, you use it in some way that it has adverse events, they are now responsible for reporting those adverse events, and they can be quite concerned about that. So what are the challenges? First of all, there has to be clear ownership of the material. Who owns that material? Who developed it? A new invention requires an invention description, a disclosure, and filing with patent offices, not only in the location in which it was developed, but worldwide. Can be very, very expensive to maintain those patent filings. And whenever academic development is developed through a team science, there's additional complexity and definition of who is the inventor. And at least in the US patent law, if the right people are not credited with the development inventorship itself, you can invalidate the patent entirely. So if you have not included everyone who should be included, that puts the entire patent at risk. So there's often a lot of work done at this initial time. There are country laws and regulations that have a big impact in this arena. Imagine the privacy laws that now surround many countries' ability to share data externally from a country. There are institutional processes and expectations. Very often, individuals in institutions don't even know that they need an MTA or a DTA to transfer something out or to get something and receive something. Those processes are often very lengthy and complex. And in the end of the day, all the parties have to agree, which means that you're going to have lawyers and teams of lawyers negotiating, and all it cost, the lawyer's time even is significant cost to the institution. Even if they're paid, they're not doing something else, even if they're covered. But, one has to balance the amount of time and cost versus the potential financial or other benefit. I have seen MTAs and DTAs take months and months and months to negotiate. So while it's very important, it also means one should be ready to focus on those important aspects of a DTA or MTA, and whenever possible, have a master agreement in place that you can start from. The concerns vary in nature and importance between the commercial and non-commercial uses, as I was saying. MTAs are very important for state-of-the-art materials, but we also have to worry about the defined use. What permission slip are we giving people? And then what do we do if there's misuse or dual use? Not only, use for good, but use to make something more dangerous. What do we do about the biosafety concerns? We're concerned where one entity is charging a fee or paying a fee for the materials to another. Whenever money is involved, it looks like people get more and more sort of concerned about the content of the MTA or DTA. Confidentiality, privacy, and publication rights, often a very big issue. You know, if somebody is giving you a state-of-the-art material, they don't want it transferred to a third party without them knowing and without them giving permission as well. They also often want publication rights. They want to review a publication before it goes and is submitted. Usually we give, at least at our institution, 30 days for a company to review a potential publication. And they want to review it not to change what we say. We won't let them do that. But what we do say is that they have 30 days to file additional patents or other protections if they think that's necessary. Intellectual property rights, including the ownership, and then the fact that you cannot modify the agreement without agreements of all the parties involved. You can't make improvements to the materials without telling them. And in MTA outs, we always require continued access to that material for education and non-commercial uses. So if we give let's say an observation or material to a company, we retain the right to use it for education and other non-commercial material uses. Revenue sharing and access, how much is each party going to get? Representations and warranties, I represent to you that this is the material it is. You don't have to then go verify it. And I'm responsible when I represent something or warrant something for whatever is claimed. And then an important consideration about liability and indemnification. If I give you a material and something bad happens in the use of that material, who's to blame? Who's going to get sued? Who's going to pay? Governing law and the process for dispute resolution. When something goes wrong, am I all of a sudden defending myself in another country, or am I in my own backyard? And then what happens to modify and terminate the agreement? Each of these are important. They, again, are more important depending on the risk of the material versus the commonality and the safety of the material and what the further purpose can be used for. So each of them, even with a master, needs to be thought about depending on the individual situation itself. So how does this work? So first, the request for the sample is initiated. Usually the provider of the material, once they receive the request, generates the MTA, and that may or may not require an ethics review at that time, or go back if you've obtained material from a participant who gave informed consent, to go back to that informed consent and make sure that giving it for the use in which it's intended is consistent with the consent that was provided. So there's some pre-work that needs to get done by the provider. And then the requester, the person who's going to receive the product or data, reviews the MTA and DTA that is offered to it, usually sends it to their lawyers at that point or to the institutional representative. And then a biobank or repository, if they're engaged, if the materials are held somewhere, you also have to review the terms for which it was deposited or it can be released. There's legal and institutional review, and then it's executed, and then there's follow-up and oversight that continues. So as I said, with data, there are special concerns with data transfer, sharing, and use. One has to be particularly careful about the privacy of personal data, what will happen to identifiable health information and non-health personal information, social security numbers or the equivalent, and then to make sure that handling of that data, transferring that data, is concordant with national laws, regulations, and practices. What are the most concerning issues with DTAs with data? First, that there are diverse data transfer agreements, which are often not reusable, handled manually, take a lot of time. There are variations and errors in the vendor provided data that need quality or control before they're used. There's really not a standard and a workflow, a known oversight. And often those require mandatory manual reconciliation reviews so that somebody can't change an electronic document just as you're about to sign it. And then we need metadata in order to really be able to find these MTAs and DTAs in a way that the institution controls that so that they know what they're given out and brought in, whether that institution is academic or commercial. There are often very many changes in specifications. How much of that has to be documented and maintain the documentation? Who is responsible for that? There's a lack of real-time reconciliation as the use changes or as the product changes, particularly true with applications of AI, for instance. Who is responsible for maintaining the currency of the documentation? And then there's an absence of robust communication and governance structure. Often people in the institution don't know who's supposed to be doing this and don't know where to send it. If I want something, can't I just ask for it, they say. And then bio and data repositories are generally created with a research protocol that goes to IRB or ethics review and defines how materials or data will be deposited, how they'll be released, and how they will be used. In other words, DTAs or MTAs define the terms of the deposit of the materials, the distribution, the terms of withdrawal from the repository and use, and subsequent withdrawal after the first and what the subsequent uses can be. It requires significant IT infrastructure to match the biospecimen, data, elements, and the use and where they've gone, and make sure that you have oversight protections involved. And I think that it's important to make sure that you know this before you deposit material into a data or biorepository to understand what their infrastructure is. But repository will also execute these agreements when they're exchanging data or materials to one another. So who can sign? So first of all, an institutional representative with signatory authority. The signatures these days can be wet. In other words, I need an inked signature. Usually we provide in the agreement itself that there is digital or electronic signatures. And then there are many now applications that you can do over the web that actually are verifiable documentation and documented electronic signatures. I do have to say you have to know and communicate throughout the organization that only some people can sign. I had done, when I was senior vice president for research at the Brigham and Women's Hospital, I worked through master agreements with all the major pharma companies. And when I got to one pharma company, the company representative said, "Oh, we have a master agreement with the Brigham." And I said, "You can't, because I'm just doing that now." And he said, "Oh, no, we do." And he pulled it out. It turned out that it was a technician who was ordering supplies for the OR 4 years ago that had signed for a master agreement for all of the products from that, because they didn't know that it was a master agreement. They thought they were just ordering, some parts. So you have to make sure that everybody knows that this is a controlled process itself. This is not really considered fascinating work. The cartoon says, for the interim committee's first agenda item, how about we take a swipe at the text for an MTA? People really, it's really sort of technical legal work. And most of the time, as scientists, doctors, and healthcare providers, we just want to get on with it. We just want to go to the next moment. But it's important to pause and make sure that we can do this work with the appropriate responsibilities known to every party. And with that, let me stop sharing and see if there are questions.
Thank you very much,
Sure.
Barbara. It's interesting to see how your presentation relates to many issues that we've discussed before. And we do have one question, but I thought I would ask you to elaborate on something that is mentioned, that I think is really important, that is mentioned for the first time in our workshop, as far as I remember, and that's the right of first refusal. And I'm gonna share the question that we have in the Q&A, so you can address both together. And dear participants, we're very happy to have Dr. Beer with us today, but she stepped out from another meeting to join us, so she will not be able to stay for the entire session. That's why we're doing the questions now. So the question that we have in the Q&A is like, how about patient data from administrative and clinical records in a public hospital? Do you need a DTA to use that for research purposes or not? And I'll pass the mic to you.
Oh, so very interesting question. So it probably depends on the country, but my feeling is at a minimum, for ethical reasons, and for making sure that it's within, that the research will be for the social good of the, of the population. It should have ethics review before the use is decided, and there should be an MTA or DTA, depending on whether you're transferring biospecimens, for instance, or data. The reason for that is a couple of things. First of all, there are uses which participants may not anticipate, which patients may not anticipate, and which some might find to be socially objectionable or not in their value system. And I think we should try to respect that. Even if you don't identify them, somebody who knows that their data is being used for a purpose that they would not have, want it to be used for, is something that requires review by the institution. And then certainly, additionally, you want to control its downstream use. I'll give you one quick example just to say. I was on an ethics committee where somebody was looking at treatment for high blood pressure in the inner city in one of the cities in the US. And the associated data with that blood pressure from a clinical record, and the blood pressure had been transferred for clinical trial purposes. And the data was requested to look at the rate of sexual abuse, rape, incest in the community. That is not what people anticipated their data would be used for. Even if they gave permission, they would not have thought of that as a possible, sort of secondary use. So I think we need to make sure that, first of all, the use is going to be for the social good. And second of all, that it is something that the general population would not have trouble with. And if they would, then it should go, even if it's de-identified, to an ethics committee for review.
Thank you so much, Barbara. There's a similar question. Oh, sorry, if you could say just a tad more about right of first refusal.
Oh, the right of first refusal. So that is when a company, you give, so a company gives you as an academic researcher a material, a product, or something, and you are going to then use it to further your research. In your research, you make a new discovery. What the company is going to do is say, that's fine, it's a new discovery, you own the IP for that, but you used our information to get there. And therefore, even though we don't have the IP to your derivative claim, we want to be able to negotiate with you for any further development that you make. Therefore, if you have something, come back to us first. We need to be able to have a negotiation with you. If we fail to reach agreement because you think it's worth so much money and we don't think it's worth that much, you go out and find another person who will pay it. But then you have to come back to us and say, we have somebody who will pay for this at this rate. We want to be able to decline that. That's right of first refusal. Did I make that? Did I say that right? Okay, good.
Yes, and I think it's a really important concept because sometimes not everything can be anticipated, and then that may give a provision that can be really important in certain circumstances. So, Barbara,
and it doesn't limit you to negotiating as hard as you can, because you're not bound, but you also are fair to the people.
Correct. So I don't know if you have to step out, or if we can do one more question.
Sure. There's also one other derivative, when you give as an academic, you give it to a company and they don't do anything, we often negotiate a right to take it back. Because sometimes companies don't do anything with your material. What they want to do is block development, or they do a little bit and then they change direction. And then all of a sudden there's nothing that comes out of it. So if they don't do anything for, 24, 36 months, we say we want it back.
And I think that's really important, because in my experience, that happens a lot more often than what we think, and gives a new opportunity to the initial institution to assess what can be done, given that the original plan didn't work out. So just one final related question. So what happens when you need to transfer materials from one institution to another project, from one research project to another project? So do you need to reconsent the participants that provided the samples again, or not?
Oh, so within one institution, it's not an MTA, it's an issue about the informed consent itself. What I would say is you have to go back to the informed consent, read it, and see if the initial consent would have envisioned this use. If it does, that's fine. If it doesn't, then I think you should, there are rules around whether it's practicable, whether you need it identifiable. If it is identifiable, you should go back. If it's not, and you can use it, then you have to decide whether that is envisioned by the original informed consent. If you're doing that and going outside the institution, the process is the same, although you're bound those external folks with a data use agreement so that they can't then use it for another purpose.
Thank you so much, Barbara. And this does relate to our previous discussion a week ago on how important it is to have clear, non-ambiguous language in consent documents, because it's not that you just need them now. You may need to go back to that to them in the future. So thank you so much for being with us today, and we're gonna move now to Ana Palmero's presentation, and I'm gonna be switching to Spanish again. Ana Palmero is
Ana Palmero is an attorney
de formación. Ella es
by training.
I'm gonna talk. Ella está especializada en bioética.
She specializes in bioethics and has worked in the research office of the Ministry of Health of the Argentine Republic. She has contributed extensively to the regional bioethics program of the Pan American Health Organization on several occasions as a consultant. That's why she's quite familiar with this for us. And currently she's a consultant in the area of ethics and governance in WHO. Go ahead, Ana. Thank you so much, Carla. Thank you so much for the invitation. It's always a pleasure to share time with you.
Bueno, en esta oportunidad, lo que voy a presentarles es
what I will be presenting to you today is our Argentine experience in the area of MTAs. It was very helpful to have Barbara's introduction at the very beginning, because you will see that many of the things that Barbara mentioned, we have attempted to include in the Argentine framework we have prepared for biobanks. So my presentation will be to discuss the data and material transfer for biobanks. As Barbara said, these are legal contracts, and they are governed by all the national laws that we all have, and given their specificity, they require a certain level of expertise in order to ensure everything that's necessary is included in the agreement. In our case, a decision was made to include specific matters that pertain to these agreements in the guide that we have prepared for biobanks for research purposes. It's an ethical and technical framework for research biobanks that complements the research guidelines that have been prepared for human beings. And the main purpose is to provide guidance to researchers who make use of these biobanks. And since the purpose of the biobanks is to store materials and data, the purpose is to set up a framework and explain how this should be done ethically, with respecting the rights and interests of the donor of the samples and their communities as well. And the main purpose of these biobanks is to promote an exchange of samples so that they can be used in research that may be of value to the health of our population. So this is a guideline that was discussed within a commission of experts and stakeholders involving biobanks and various disciplines. And it came about because of the need to have a framework for research that would benefit the biobanks and would allow them to operate ethically. Because as often happened in Argentina and other countries in the region, that when you don't have a specific framework, then it was extremely difficult to understand what steps need to be taken, what processes need to be followed in order to protect those persons donating their samples for research purposes. In this case, they are stored, but there's still a tie back to the donor. These are samples that sometimes are identified, and it involves research involving human beings. So From that discussion, came up the need to establish factors that have to be taken into account when you prepare a material transfer agreement. The main reason we did this is, as I said, the purpose of biobanks is to store biological samples for research purposes. We the whole use of the material is formalized through the MTA. As Barbara was saying, we have the same mission. It's a contract that governs the transfer of materials between two or more organizations. We talk about the provider, which in this case is the biobank, and the recipient is the institution. It's important to say that we're talking about contracts between institutions. If these samples in a biobank want to be used within the same institution, even though there are different research teams, then no MTA agreement is required. It's only necessary when the samples or the data are going to leave that institution who was authorized to use it, and it is now going to go to a different organization or institution. These contracts establish the scope and limitations of the use of the materials and data, and the rights and obligations of the data bank, the provider, and the recipient. And we include also DTA because it could be that within a biobank, they don't share samples, they only share the data associated with those samples. Therefore, in that case, you need a DTA as well. And if you're transferring both material and data, then you need an MTA and a DTA as well, or an MDTA. One reason we included this in the ethical framework for operating a biobank is that we felt this would serve as a tool that would ensure that materials are shared in an ethical way. Why? Because in the terms of the agreement, we could include all the ethical commitments we made to the donor when the donor shared or donated their samples. And also, all that has to do with the biobank itself, particularly when you're talking about international collaborative work, where transfers may be done between institutions in the country or institutions in a different country. And so one thing we wanted to guarantee, and that's why we felt important to specify it in the basic terms that have to be included, is that allows you to ensure a fair and equitable collaborative association. Barbara mentioned this because very often researchers or research teams from one institution deal directly with a team or an institution in another country, and they receive a predefined agreement from the recipient organization. They have already a predefined agreement that is based on the standards of that country, not on Argentine's standards, and therefore they may not have a local review process. The researcher may not necessarily have the proper tools to analyze that contract that has been given to him. And what we often found is that these predefined contract was sent to the Argentine institution and they just signed it without really evaluating or analyzing what they were signing or agreeing to. So this new tool allows you to think about all these ethical commitments you're making and making sure that the negotiation of the terms is done fairly and equitably for all parts. It also allows you to identify the biological materials so that they can be recovered if needed. And that's important in an international agreement. It's important to be able to recover the material as well as the information and the results generated from that research. And it's an ideal place where to include the local benefits. So that is the moment when one should negotiate what's going to be established as a benefit from each one of the research done. And finally, the most important thing is that it is a legal document because it establishes the ethical obligations of both parties, the bank and the researcher that will be using those samples. What the guide establishes are the minimal terms that need to be included, where you need to begin what you need to begin negotiating a fair agreement. First of all, we established that you have to describe the material and or data to be transferred. It has to be clearly identified. Then you need to lay out the purpose of the transfer, the names and purpose of the research project, and what will be the conditions for the use and restrictions, because these use conditions need to be included in the need to include what the informed consent said when the donor gave the material. You also need to take into account that since these agreements are for a biobank, then the biobank has to have proper governance so as to ensure and protect the informed consent, which the patient allowed their samples to be used in the future. Because when you ask, it could be that you can't tell the donor exactly what their materials will be used for. So you need, if a biobank has appropriate governance, then it will be able to assure the donor that in the future, what it said it would do for the donor will take place. The agreement for transfer and materials is a specific place where I will go to see what the donor actually granted and what the ethics committee agreed to. That's why it's so important that the local party can analyze and sit down to negotiate the terms of the agreement. Doesn't suffice for the other institution from another country define what should be the terms. And also the proper place for including any restrictions on the use of the material. Maybe it cannot be shared with third parties. It can be used exclusively for research purposes or whatever other restrictions the local bank feels needs to be done in terms of the donor. In terms of confidentiality, this usually applies to all research biobanks. The researchers that have access to the biobank samples should have access to them in a de-identified way. It should be codified, but they never should have access to samples that are directly linked to the data of an individual. And to do that, a contract has to clearly establish the process that needs to be followed in order to prevent the recipient from being able to re-identify the samples, particularly in genome research. Of course, we realize that with progress of time, it's going to become easier and easier to re-identify genome samples. So these clauses that forbid re-identifying have to be clearly included in the agreements. On the custody, the access and control of the material, it's also important to establish that it should be in the hands of the provider, the biobank. They could request the destruction of the material if the agreement has been violated. Also, it's important to keep that in mind because biobanks are the custodians for all the samples and all the data that they contain. They're not the owners, but they are the custodians. Therefore, they have the responsibility of ensuring that data and samples will be used for the purposes that the bank has and for the purposes allowed by the donor. Also, they need to have guidelines on biosecurity. How are they going to handle the samples, even during transportation and when the material is actually used? The report on use, we established this because we wanted to have the biobanks to have follow-up on what's actually happening with the samples, since they have the obligation to keep the donor informed. So by informing on the use, they can report on what's happening with the research that is using those samples, and what's the final purpose of the material or destination of the material, whether it'll be returned or destroyed. And it must follow whatever conditions the biobank establishes and define what will happen with the material should the agreement end. All those things that have to do with intellectual property have to be mentioned, because it should provide a plan for whatever would happen should their intellectual property be required. And this is a very important point, because very often there could be an invention that comes out of the use that leads to great profits, and it's very important, therefore, to have a fair negotiation, that this should not be just a pre-established clause that is established by the institution that will be using the samples.
Now, in terms of publication, there has to be acknowledgement. So everybody that contributed on the part of the sender, whether it's authorship or contribution, collaboration, everything has to be included in the agreement. Also, the publication of results and return of results. This has to be taken into account, because biobanks may request or require that results are returned in a specific form. That's why we said they need to be returned in the format requested by the sender, not just let them know about the publication. And in terms of the benefits, as I was saying, anything that could be negotiated in terms of the benefits stemming from this research, because let us remember that benefits are not just direct benefits to the donor, but when we're talking about these type of research, it's very unlikely to have a direct benefit. It's a different kind of benefit. Also, we need to build capacity in terms of research, especially in countries like ours, where this is just now taking off. So basically, to include in the agreements everything everything related to the receiver to be able to contribute to build capacity. And finally, these are general terms that are applicable to any agreement. So basically, the commitment to abide by current legal standards. Like I said, since oftentimes they are already reviewed by units from the other units, they go by their rules and regulations, and we need to make sure that there is a match to what our local laws provide for, also how potential disputes may be settled and where. Sometimes it says that any and all settlements will be negotiated in the other country's court system. So a researcher may not necessarily know about all these legal aspects, but so that's why we have to submit the information at the legal department of all the institutions involved, so that the right terms could be negotiated. The duration of the agreement and also the signature or execution. It's important, like Barbara said, to have a responsible party sign on behalf of the institution. In any biobanks, the researcher is doing his or her work within an institution. They are not doing this in isolation. and there's liability for a lot of people. So if a contract is executed such as the MTA, has to be signed or executed by the responsible party. So the authorities, director, or whatever the position is, but a person that is authorized to represent and sign on behalf of that institution. Because sometimes we see cases where the researchers themselves sign, or sometimes the agreement is given to the director. They sign it, but they never read it. I'm talking about a person that could weigh in on what should be included in the agreement or not. So everything is signed, and then we have legal consequences. And then finally, the approval decision by the Research Ethics Committee and the research project are part of the agreement as annexes, so that we stipulate what project this agreement refers to and what conditions that project was negotiated under. In terms of other issues or other business, well, in the case of transfer from other countries, or especially when we're talking about a multi-site research project where there's one country that will transfer all the samples, in those cases, we also require MTAs or sample transfer agreements. And what we're saying here is that the receiving country has to have a level of protection that is similar to that of the sender. So one of the discussions we were having is who ensures that all the legal aspects are provided for. And we said, no, it cannot be a researcher because they don't have the know-how. Rather, we need to have the legal units involved. And that is why it's so important to have trained individuals at the different institution levels to do this, and for researchers to know that they have to go to them and to never sign any kind of agreements on their own account or as part of a research team without going to the legal department. Another discussion to conclude was around what the Research Ethics Committee role plays in these agreements. Well, initially the discussion had to do whether the Research Ethics Committee had to review them or approve them. And the decision that was made was that, first of all, if the committee has any kind of obligation in these agreements, is to make sure that one is in place. So whenever a project like this comes up, not just for biobanks, but in any situation where samples will be transferred, the first thing they need to do is to ask and inquire whether there is a sample transfer agreement in place, to remind researchers that they have to be. And as part of their role, they are not required to evaluate it because this is a legal document, therefore it needs to be reviewed by the relevant people. But they need to be aware of these documents when they are in place. Why? Because IRBs in general receive a research project, and at that level, at that point, these agreements have not been negotiated yet. So more likely than not, they won't be able to have the latest version until the agreement is executed. But in the future, they could request it, but it's very unlikely that when the process just starts, the agreement be in place to be discussed. Thank you very much. Thank you so very much, Ana, for sharing this recent legal framework from Argentina that, even though focuses on biobanks, is the only one that has been developed after these SIOMS guidelines. So we're going to hold questions till the end. And now I would like to invite Daniel Barta de Matos Almeida.
Daniel is a lawyer by training, and he's the technology transfer manager at Fiocruz University in Brazil. Fiocruz University is one of the main research entities in our region, and it's involved in a number of research projects throughout the world. And Daniel has wide experience in the negotiation of MTAs, including with important international counterparts like NIH that have been part of this workshop. And it's great to have Daniel with us today, and we look forward to hearing from him what he thinks we should be doing looking to the future in terms of MTAs. Thank you, Daniel. Go ahead.
Thank you very much, Carla. Are you hearing me? Yes?
Yes.
Okay. It was good to have, first, thank you for the opportunity to be here and to talk with everyone about this important subject. Although I'm a lawyer, I'll refrain from talking about legal terms and legal aspects in detail about the MTAs, because I believe you already saw that in the previous presentations. It was very good to have Barbara and Anna before me. My idea here is to talk a little bit about these important activities within a research institution. And how we support the researcher in doing this, because I believe that the researcher must be focused and must know about his research and what he wants to do with it, and the institution must support him in dealing with several aspects related to that. So he doesn't need to be an expert in MTA and DTA. You must know they are important, why they are important, that they exist, and when they should follow and ask for the opinions, how to use them, and which MTA they used. So for this, I'll try to give a little bit of context about the institution, so that we understand a little bit of what I am talking about. So Fiocruz is a leading research institution in Brazil, has 123 years promoting public health. I'll go briefly about the little details about the institution. It has the mission to disseminate and share knowledge and technology aimed to strengthening the consolidation of the unified health system in Brazil. Brazil has a unified health system. It's the biggest unified health system in the world. It's based or inspired by the NHS in the UK, and has a broad spectrum of activities that I'm going to explain a little bit, just for contextualization. It's a public institution, as I said, linked to the Ministry of Health. So all the federal actions related to health usually involve Fiocruz to a certain degree. It's also spread around the country. So we have we are present in 11 states, have 16 scientific units, 5 offices around the states of Brazil. So it's quite a challenge. We have a main campus in Rio de Janeiro, but several other scientific units across Brazil. Fiocruz also contributes to production, so has 40% of the drug purchase of the Ministry of Health are produced by Fiocruz. This is the largest manufacturer of vaccine against yellow fever. Produces about 6 million reagents for several diseases that are on the screen right now, and was able to produce 100% national COVID vaccine during the pandemic, which was quite a challenge. Some numbers of Fiocruz in 2022. regarding the scientific production. So there are a lot of doctors and research projects inside Fiocruz. The production of vaccines, pharmaceuticals, diagnostic kits, and biopharmaceuticals. The education, we play an important role in education in Brazil and also in health assistance. Why I am, and also you can see in this slide the cooperation, international cooperation of Fiocruz. Fiocruz has several cooperations internationally, which are very important for our activities. But I won't go into detail with every one of them. But why am I saying that? Because dealing with all these kind of activities, production, healthcare, education, information communication technology, quality control, research, we obviously deal a lot with MTAs and DTAs, which play an important role for our activities. As you may think, it's quite a challenge in the size of institution to have everything aligned with process and workflows and everything. And also, it's important to notice that within this framework, there are very different perspectives and proposals for an MTA or a DTA to be used. In our institution, we have all of them. We have research and development, biological collections, biobanks, biorepositories, services that we provide, and I probably forgot to mention some of it also. But each of these activities have different perspectives and details and common terms that are used in the MTAs. We understand that the MTAs and DTAs, they not substitute the partnership agreements or cooperation agreements. They are for the provision of the biological materials and the data, and to regulate that. If it's within a partnership, this partnership agreement will govern the general terms, which might include terms related to MTA or DTA, but the material or the data must follow the guidelines set forth in the MTAs or DTAs. If there is a partnership agreement, it could deal with all the matters related to data transfer agreements, and the DTA might not be necessary. But usually the MTA, when sending materials or receiving, it's important to notice that it must be signed. So in the research, we deal with usually a material that the researcher is working on. It's not necessarily a material that is present in the biodiversity or it's unchanged. It's like they found it in nature. So it has different concerns. Biological collections, we are dealing with material that is found in the environment, in the conditions, but may have special characteristics. And this happens with biobanks and biorepository and service provision. So it's very important for the institution to have institutional models that are aligned with, as closely as possible, with the commonly used terms internationally, mostly, but inside the country also. Sometimes we find that within the country, the models or the MTAs are usually a little bit different that used internally. So we can have a MTA for international partners and an MTA for national partners also, because usually they deal with a little different provisions. But if you are able to find a model or a contract that is commonly used terms, usually the negotiation relies on the jurisdiction, applicable law, intellectual property, rights over modifications, the definition of modifications. The MTA has some different definitions that are very technical, and you must pay attention to them, and transfer to third parties. And also, it's important to notice that the negotiation of MTAs depend on the leverage, the bargaining power that you have in the negotiation. And if you want to send the material if a partner wants to receive a material from you, or you want to receive a material from your partner, that usually depends on the interest, the need, the importance of the material, the rarity. When I say material, I mean also data that could be exchanged. The rarity, the availability, the quality, and also legal limitations. If you have legal limitations and your material is rare and it's important for the partner, the legal limitations can be negotiated, and usually the partner agrees with some limitations in order to receive the material. So this is the job for the researcher. I don't think it's only the researcher. It's important to have a partnership between the research and the staff that supports the researcher in dealing with these aspects. In different institutions, there are different professionals that deal with that. I'll go in detail a little bit further, but this is important to acknowledge, and also it's important to recognize that biological material and the data associated to it can be a valuable asset. Sometimes the researchers don't think about this, and we agree. The institution is led to agree with some terms that are not very good, or they could be better if you understand these factors in dealing with the transfers. I'll go in detail a little bit about the national regulation. Not bioethics is not biosafety, but related to genetic resources and its impact, the impact it had on my institution, on Fiocruz. As you may know, there is a convention on biological diversity that provides for sustainable use of the biodiversity, benefit sharing, and exchange of and conservation of biodiversity. Brazil signed this convention, and we dealt with internal legislation to regulate our legal system to this the provisions of the convention. So this was done in a hurry, very poorly in the beginning. The institutions and the researchers didn't know about the law initially. Then they became aware of the law, but the law was very poorly done, very complicated, with a lot of subjective dispositions, and was very hard in the beginning for people to comply with these regulations. Then they try to improve, but they use the previous law as a base for the improvement. So they solved some issues, but some of the other issues were created or were maintained. So it had an impact in our negotiations regarding especially MTA related to the genetic resource derived from the biodiversity. So this regulation deals with the commercial use, the benefit sharing. It mandates that you must have Brazilian jurisdiction and law, and also has mandatory clauses that should be put in the MTA. You can see here that some of these aspects are the same aspects that I mentioned before, that of the clauses that are usually negotiated if you have a reasonable and common with MTA or contract with commonly used terms. So this poses a challenge for us to negotiate the main clauses in our MTAs. We haven't solved that yet. We are trying to improve awareness about this issue, but we are dealing. So before this, we had a different management or organization of the MTAs inside our institution, and also the DTAs. The workflow was not well defined. They used different models. Sometimes it went for the legal team to negotiate or to see the contract. Sometimes it didn't. The researcher went and tried to have it signed by other means. So this regulation, as it's set forth some fines if you didn't comply when you were sending MTAs to biological material outside of the country. If you were audited by the sectors that do the fiscalization of the material, you could be fined. The researcher could be fined that sent material, and also the institution. So this made necessary for adjustment not only in our institution but in several institutions in Brazil. So there was a positive externality, if I can say that, to this regulation. We managed to have a institutional policy related to the material transfer agreements, a consolidation of the workflow related to these material agreements and DTAs, but especially material transfer agreements. Awareness that I didn't put here, but by the representatives, the top management of our institution, of the importance and the consequences of not following the right path to send this kind of materials abroad. So we also managed to make institutional models for different situations. So the biological collections, we dealt with the different aspects of it, the research and development, which is more focused on innovation and products and services to be developed, and probably intellectual property is a more important issue. So this kind of situations, we deal with different models to start the negotiation. It's important for the provider to be the one who sends the model, because it helps a lot in the procedure to have it signed. Also, there is a TTO support in negotiations. I'm going to talk a little bit further about that. Internal processing and approval procedure is much more consolidated, and also aware. The researchers are aware of this kind of procedure to send the material. The signature by a legal representative also is now something that is done with much more much more easier to have the legal representative to be secure and knowing that the procedure was followed, and he can sign the document was all the different instances analyzed and approved the document, and he can sign. Also, the Fiocruz also has an important export sector, which is very important to deal and to lift the burden of the researcher with some activities that also need highly regulated and specific for different types of material, especially. So custom clearance career hiring, compliance with legislation, environmental, sanitary, biosafety, documentation that needs to follow the material, and also traceability. This is not perfect yet. We are still improving, but this kind of arrangement that we managed to make was not easy to do. Helped a lot to deal with the MTAs, and also to securing better negotiations, understanding the kind of material that we're sending and the possibilities to be done with that. So this was done also. It was very important, the management model that was implemented during this decades. It was a slow process, but we managed to have this implemented. We have it was like a small TTO in each unit of Fiocruz. As I mentioned before, Fiocruz is spread out a lot through the country. So it's important to have someone that is in dealing with several aspects related to innovation and to the regulation related to research. So the researchers can access those people, and they can access the GESTEC, that is the main TTO of Fiocruz, and we can have a network that help each other to make the projects possible, and to send, in this case, the materials abroad and the data also. Some important considerations that I believe that the institution, the researchers, and the staff that support these activities must consider is the origin of the material, because there's some, as I mentioned, Brazil has this law, and if it's not from Brazil, we don't have the same regulation. Ownership of the material, third-party rights. Sometimes biological collections receive materials from third parties subject to specific conditions. It's not only in case of human samples or human material related to informed consent. Sometimes we receive materials that are not donated. They are to be used under certain conditions. So the provider must be, for instance, if there is a perspective of commercial use, you should contact the provider to authorize that, and in several other conditions. So third-party rights must be checked before we agree with a specific research or with modification of our models or templates. When I say models, it's like probably more correct to say template. And also informed consent and authorized use, as was mentioned a lot in the previous presentation. And I would like to emphasize as my final comments is that in my experience in dealing with this activity, it's important to recognize the importance of the biodiversity and how we collect material, we store, we characterize them and maintain them in biological collections. Also, the material related to human sample and diseases in the biorepositories or in the biobanks. It's important assets for the institution, and it provides bargaining power. It's not the institution must recognize that to get better negotiations and to receive some kind of benefit from the exchanging this material, because especially related to biodiversity, since in our region we have a lot of biodiversity that is preserved, and this is an important asset, and it should be used to get better contracts. And this is it. Thank you very much.
Thank you very much, Danielle. It was great to hear about the experience and the very specific details of the processes and the different scenarios that are considered in Fiocruz when doing MTAs. I want to invite Anna to join us too, because we want to discuss some questions that we have from the audience. And I want to say to the audience that some of your questions have also been answered in previous sessions. This is the 4th session of the workshop. So I want to, I'm gonna try to prioritize the questions that have to do with the specific experience that our panelists have shared with us today. So, and I guess I think I may switch to Spanish, or not. Okay, I'll switch to Spanish. Tanto en las presentaciones que nos han
In
hecho.
the presentations that you've made, you've talked about the legal framework. For instance, in the case of Argentina, you talked about the institutional experience covered by law and the institutional experience of Fiocruz. And many of the colleagues who are participating in this session may not have a national or institutional framework similar to the ones you've described. And they're asking if there are models that you could share with us. For instance, in the case of Argentina, do you use some sort of national model? And Daniel, in the case of Brazil, do you use different models that you could share with the audience for institutions? That's the first part of the question. And the second part of the question is in the area of ethical review, how in your country or in your institution, how do you include ethical review? But in terms of this question, what I'd like to do is ask you to consider this question and think about other institutions, other countries where there's a new concept. How? Say there is no national law or national policy such as Fiocruz has, where there's no institutional policy. How can other institutions, how can other researchers, how can other research committees begin to address this process? I don't know who would like to begin. Whoever turns their mic on first. Ana?
Okay, empiezo.
I'll start.
Con respecto a modelos, sí puedo compartir, Carla, si quieres.
In terms of models, I could share them with you, Carla. I could send them out so you can share them. When we were developing our guideline, we looked at a lot of different agreements. Many are in English, of course, but we now have some contract models because these are models between private parties. There is no national model, and you can have pre-established templates, and they will, of course, be adapted and changed based on the specific project and the other institution. But I could share those templates with you. In terms of the review by the committee, this is a discussion that came up also when we were thinking about developing this framework. And I'd like to think of different scenarios, not just biobanks, because biobanks are different. Their job is to share samples. So for them, the model would be a transfer agreement model because they've already established the laws for access to the biobank. And those laws are already, or those rules are already established. In Argentina, for instance, one of the biobanks has a template and it's based on our resolution. But in the case of other situations, or say there are no regulations, then these become legal contracts. And each country has laws as to what applies to or how you do a contract between private parties. And in this case, since these are institutional contracts between two institutions, they have to be drafted and reviewed by the directors of the institutions, with, of course, their support of their staff, because the staff's the one that provides all the information. Now, as to the role of the ethics committee, I would say the same thing. Generally speaking, when a project is presented, a draft is presented, the agreement has not yet been finalized. Now, if the institution has a model, well, they'll look at it and use that. If not, they'd have to create a new model or template. But that's why we emphasize the need of having models. If you're going to transfer material from one institution to another, the role of the committee could be, have you thought of how you're going to transfer these material? Or have you thought of the importance of this agreement? It may be they have lots of paperwork, but they haven't taken into account what the responsibility is of the person who signs the agreement. Same thing applies to the contracts for clinical trial. The committee may be informed, may look at things, but they don't have the expertise to review and define exactly what each clause has to say. That's not their job. Usually it's attorneys who can do this on a professional basis and who can decide what the institution should include in their language. So the committee can ask, is this included? If there's a data transfer, do you have an agreement about it? But their job is not to review it and make changes. They can make suggestions, but the one who actually signs is the one responsible and represents the institution. That's why it's very important to define these frameworks and have an institutional framework. Now, it may have been looked at by the committee, and the committee can say, well, you need to include these ethical issues. But if there's a contract between two private parties, that's not something that the committee, that's not the committee's job to define what those clauses should be.
Thank you, Anna. Danielle, go ahead.
Yeah, as I mentioned before, I believe that it is important to know how these documents are negotiated internationally. Because if you're going to make a model of only to use inside your country, you may structure it in a different way. And when you use this with international partners, you can have problems. So they are usually pretty standardized terms, or the main aspects that are dealt with within these documents. Anna already mentioned with regard to biobanks, and Barbara mentioned before, they're the same aspect. The negotiation comes when changing a little bit of each provision of the contract. So to do this activity, it requires some training, some expertise, but you must know the common terms to know if it's a provision that is being negotiated in a contract is not usual, why they are doing that, and if you can or should accept those terms, and in this case, considering the purpose that you are doing for the transaction, why you are sending the material or receiving the material, and your internal regulations in the country, if they are applicable to that. And also, when you don't have a national regulation with regards to some aspects involved in here, I believe that's important to look for the best practice internationally, to use that as a starting point, because when you are going to cooperate with other parties in other countries, if you don't follow the specific regulations that are generally accepted internationally, and compliance is a key aspect with companies and institutions. So if you don't follow these internationally accepted guidelines, which are usually the national regulations are based on those guidelines, so they usually quite aligned. You might have problems with going forward with your research or accepting patents or negotiating a technology which was developed under insufficient guidelines or regulations. So I believe that you should follow the international experience and find what is the standards usually used in this kind of activity.
Muchas gracias, Daniel. Creo que
Thank
es
you so much, Daniel.
resalto dos puntos fundamentales.
I would like to highlight two main aspects from that response. First of all, we all know that health research has an international dimension, and we have to take that international context into account because it is key. And we could also say that once again, we don't need to reinvent the wheel, but rather build on the knowledge that the international community already has, just like we've done in other areas. That's on the one hand. On the other hand, another thing that was mentioned in your responses, initially Danielle brought this up, then Anna did as well, the thing that something should be done does not necessarily mean that it is the ethics committee obligation to do that. One of the reasons why this is a complicated topic is because we see a convergence of a series of perspectives: ethics, legal, scientific, and we try to have a region move forward in this area. And as we do it, we realize that this convergence of different areas of work makes it kind of hard, because it's hard to bring everybody to the table and to have each one of us contribute with our own, based on our own expertise. Now, before moving on to the next question, I can see that some people are mentioning audio issues, but that might be your own signal, because we are testing the audio in different areas, and everybody is getting a good connection. But please bear in mind that this session is recorded, and we will actually share it later, and it will be on the Regional Bioethics Program website if you're having issues with your connection now. Another recurring issue here is the duration of the agreement. More specifically, how long do we store samples for? I believe that there's a lot of recent learnings, just like in other bioethics areas. At first, we kind of set some aspects aside, and the fact that samples must be destroyed after their use is one of the things that we have reconsidered. So I'd like to ask Anna and Daniel, in your own jurisdictions, I don't know if the regulations in Argentina say something about this, or what the institutional policy is for your crews in this sense. And also, if you have any kind of lessons learned that you could share in terms of the quote-unquote life of the samples and their potential destruction. Anna, go ahead.
Well, I can talk a little bit about my perspective about this subject. I believe that this depends on the material. If you are talking about material derived from the biodiversity, this should be a concern. You can store the material as long as you need. When you are storing the material and in the biological collections. When you are sending an MTA, for instance, for an R&D project, for doing some specific test, and the results are sufficient for you, usually you establish the term of the MTA, putting the time necessary to do the activity that is planned. So when sending materials to biobanks, I'm not aware of the specific regulation inside Brazil with regard to this time, but also you have to consider the informed consent if it was established there that the material is to be stored in a biobank, if it can be shared for different purposes with other institutions or companies, if for commercial purposes or not. Usually they are not for commercial purposes, but as I mentioned, there are several activities that they use MTAs and DTAs. Usually you establish a term necessary for the purpose of the activity, not establishing 5 years, for instance, for MTA, that's going to be a genetic sequence. It's something that is going to be done in 1 month, 2 months, or 3 months. That's not the what we think it should be done.
Gracias, Daniel. Ana, puedes
Thank you,
compartir.
Daniel. Anna, can you share your perspective? Now, thinking about specifically human biological samples, because I believe that that's where the potential conflict could arise. In general, a research project, as a rule, says that the sample will be kept for the minimum possible term while the information is identifiable, and then to de-identify it. In terms of biosamples, the appearance of biobanks opened up the door to this possibility of being able to engage in data sharing or material sharing. And it's also a matter of research possibly, and the possible of reusing the samples, or given the research data and the material public good label. So as a rule, in our guidelines that govern research in human beings, we ask for the sample to be kept the minimum possible time to conclude that research project. And the soonest we can decouple it from the participants, the better. And that also comes from international data protection rules, both in Europe as well as in the US. The rule is to have the sample identified for the shortest period possible. If during the study we can identify it and then de-identify it, then we should do it. Now, in the case of biobanks, where the value lies on the fact that it may be linked to the data or the participants' personal identifiable information, there has to be a sample. I mean, samples are not kept with the person's first name and last name. In the banks, those data are anonymized. The people that have access to those samples are limited, and the idea is to keep those samples anonymous even within the biobank, even though they are still considered identifiable. So in that case, and more because of technology, the rules for a biobank, I'm thinking for example, the UK biobank, which follows 500,000 people in the long term. So as a best practice, because those samples have been identified, is to reconsent every so often, every 5 or 6 or 10 years, to contact the people again to ask them whether they give their consent to keep the samples, because the idea is to keep those samples forever so that we can have population trends. So those are the rules for your biobank, because like Danielle said, this is for a specific purpose. But if there is a biobank involved, we need to make sure that people's data will be protected. All of this has to be predetermined in that project, so we can then ask for the participants' consent. But there's no rule that makes it impossible to keep a sample forever in a biobank, for example. That's exactly the case, and I believe historically the belief was that it was some sort of ethics, a requirement to destroy or dispose of a sample after a certain period of time. And actually, that's not the case. To the extent that you can keep the sample with all of the necessary safeguards in place from a strictly ethics perspective, there's no need to actually destroy those samples. And we need to bear in mind the reason why we do research in the first place. And that is that research results in benefits for people's health and well-being. So a sample holds a research potential that should be, so it should be preserved. But that, of course, means that the institutions have to be responsible for safeguarding the data about the sample. We just have a few minutes left, but very quickly, I would like to ask a question for Daniel about negotiating specific provisions. So in your experience about negotiating the details in the MTAs, and the question is, how do you handle this negotiation process when the countries and or the institutions that either send or receive samples have different positions or different policies?
The negotiation usually depends on you acknowledging what material that you have, if you are going to send the material, and how much the other person needs that material to implement. It's not that you're going to put some abuse clauses or something like that, but for you to understand that in this case, you can't have access to the results, or you can have a better negotiation for intellectual property, sharing the results if there's a development of some product, or subject to patent application, and several aspects. It depends on you knowing the material that you have. The other aspect, or that you want, how badly you want. But the other aspect is also the regulations inside. If you are dealing with a public institution from another country, as Fiocruz and several other countries, there are sometimes specific regulations regarding the applicable law, the venue for the MTA, that you can the other partner cannot accept modifications. So you have to be creative also to deal with this kind of, it's very common. Sometimes we use the defendant party, that the clause that sets out for, if you are going to have a dispute, a legal dispute regarding some MTA, you go for the country of the defendant party according to its law. Sometimes it's a compromise that can be arranged. Sometimes you remain silent on this kind of aspect that both parties cannot accept a different regulation. So it's quite a challenge sometimes, because the other aspects of the MTAs and the DTAs are usually quite standard, as I mentioned before. And there's these points of intellectual property, governing law and venue, and the modifications, which if you do a modification to the material, you will own the modification, or you understand that this material is so rare or so important that if the partner develops something through, he could not develop a product or do a research without receiving your material. So if it's so important for that, you can negotiate a better agreement that it should be reasonable. But you should not accept everything that is put to negotiate, especially coming from some kind of institutions or companies. Private companies usually do very aggressive when they negotiate MTAs, and usually their MTAs are not the standard terms that are used globally. So you should know the standard terms that are usually used between research institutions, that when you receive an MTA from a company, a private company, a pharmaceutical industry, you will notice that they are very different from the usual terms.
Thank you very much, Daniel. I think this is an excellent reminder that it's not the case that one size fits all. It doesn't. And we need to assess specific cases and specific contexts to figure out what's the right thing to do. Esta es la última sesión de este
This
taller.
is our final session in this series of regional workshops. I believe this has been a very enriching opportunity for everyone. And this is not the end, but rather the beginning of a regional learning process. We, for the first time, will have attendance certificates that will be shared via email. Please be patient, because we have over 1,000 registered participants, so it will not happen right away, but we will go by the proof that Zoom gives us to issue certificates. Once again, thank you very much, Daniel. Thank you very much, Anna and Barbara, who joined us earlier. And thank you to our team who makes this possible. Our colleague, the interpreters, also Silvina Acosta, Namfun, Sara Carracedo. Thank you so much for allowing us to share all of this information with the region. Thank you very much, and enjoy the rest of your day.
Muchas gracias, hasta luego.